Right. Hi, good afternoon. Today is Thursday, June 2nd, 2022. My name is Ashley, and I'm here with attorney Deanna Eble. And this presentation is creating the new normal for healthcare directives. As always, thank you for joining us, and we will start off with a few housekeeping items. Your mics are muted. Submit questions through the Q&A box. We did receive a few questions during registration, which we've saved time at the end of the presentation to address. This presentation is a half hour. We are recording, as you all probably saw already. We're recording and we'll email you a link to the video. Please let us know how we did in the survey. And if you need to message me about anything, you may do so using the chat box, please. All right, moving on to bigger and better things. I will give a speaker intro, give a little background on Deanna, as well as today's webinar. Deanna Eble is a partner at Russo Law Group. She focuses on elder law, estate planning, special needs planning, and Medicaid planning. She has a ton of experience in these areas, having done so for 20 years. Deanna recently wrote an article on this very topic, the healthcare directives, which was then published by the New York State Bar Association. So we thought this would be the perfect opportunity to have Deanna come on and speak as to what these directives are, why these documents should be important to you, and how the directives can help you. So Deanna, thanks for being here. Hopefully I set the stage okay, because
yeah, you did a great job. Thank you so much. And I hope everybody's doing well and recovering from your long weekend, if you had a long weekend. So today we will cover what is a healthcare proxy and a living will, who makes decisions if no advanced healthcare directives are in place, how can you protect yourself? And these are all important questions and concerns that people have, because not everybody has these documents in place yet, and there needs to be a broader understanding about why they're needed and how they allow you to have control, even if you're not able to control the situation specifically yourself. So planning ahead is always a good thing. We all know that planning ahead works, as much as spontaneity isn't such a bad thing on a temporary basis. Planning ahead when it comes to must-have healthcare documents is very important. So planning ahead on healthcare directives like your healthcare proxy, your living will, your medical authorizations gives you an opportunity to be the one who decides that in a circumstance where you're not able to step in and handle your own medical affairs, who's going to step in and make those decisions on your behalf. You want to plan ahead for that, because you want to make sure that the person who's stepping in is somebody that you know is going to do things the way that you want them done and not have their own agenda. So the first thing we're going to discuss is the healthcare proxy, which I'm sure many of you are familiar with. So a healthcare proxy, in making decisions about the healthcare proxy and understanding the healthcare proxy, we need to first know who has the right to make healthcare decisions for you. So first and foremost, you have the right to make your own decisions. As long as you are competent and awake, alert, and oriented, you are the one that the doctors are going to talk to make your decisions for you. Of course, assuming you're over the age of 18, which I'm guessing all of us are. If that circumstance comes into play where you're either unconscious or you are not competent to understand what the doctors are saying to make an informed decision, then you have this opportunity to have a healthcare proxy where you name an agent to make decisions for you. So a healthcare proxy in and of itself designates an agent to make healthcare decisions. It also allows for a successor agent. And I encourage the successor agents, especially if you have an opportunity to put more than one successor agent in there, because over the 20 plus years that I've been practicing, I have seen those circumstances where only one person was named, and then something happens that is unforeseen and that person can't step in and help. And we're in a situation that we'll discuss further where we may need a guardianship. So if you have people that you trust that can be in a pecking order for succession, I would definitely name them. It's effective only if you lack the capacity to make the decisions on your own. In the healthcare proxy, you can also designate whether or not you want to donate organs, which is important. Some people are a little shy about putting on their license the fact that they want to donate organs, because there's this mindset that if you put it on your license, they're not going to do anything for you because they just see that you're an organ donor. So having it on a healthcare proxy gives an opportunity for the person you're naming, your agent, to step in and say, you know what, you did everything you could, and now you need to know that they want, you know, my loved one wants to donate their organs if there's nothing else that you can do. It is also an opportunity to discuss your desires regarding artificial nutrition and hydration. Artificial nutrition is a feeding tube, and hydration is IV treatments to keep you hydrated, and that could prolong things a little bit. So it's very important. And on most healthcare proxies, what happens is there's language that says my agent knows my wishes regarding artificial nutrition and hydration, because we want to know that you've had that conversation. Not everybody puts the specifics on the document for a couple of reasons, one of which is because, you know, you may change your mind about what you want. And the other thing is, you don't necessarily want to have it on your healthcare proxy, because at the end of the day, if the doctors are reading the healthcare proxy and see what you want, they may not rush to talk to your agents right away if it's an emergency. So you want to give your agents the opportunity to be part of the discussion. And so that's why I always encourage that. Another question that we get often when we talk about healthcare proxies is, well, I have 3 children and I want to name all of my children. You can name all of your children or any individuals you're interested in, but understand on a healthcare proxy, it's a pecking order. It has to be person number 1, then person number 2, then person number 3. Because if the doctors had to rely on 2 people to make the decisions and they don't agree, the end result is, who do the doctors listen to? So it is a pecking order on this particular document when you talk about who has the right to make those decisions for you. A living will, which is what we're going to discuss next, understand that there are some law offices out there that combine your healthcare proxy and your living will. So they not only say who the agents are that are going to be making your decisions, but they explain what the decisions are. It's not wrong, but like I explained already, it's not the thing that we do here, because we want to give the agents the opportunity to be part of the conversation and explain what your decisions are based on the information that they're getting, and not just have medical professionals step in and say, oh, well, this is what she wanted, and so this is what we're going to do. So we separate out the healthcare proxy from the living will, and the living will has more detail in it. So we know that for who has the right to make life-sustaining treatment decisions, that answer is the agent named under the healthcare proxy if it's not you. So what does the living will do? Well, again, you always have the right to make your own decisions, assuming that you have capacity and you're awake, alert, and oriented. If you don't have, if one of those prongs is not checked off as yes, then the healthcare agent will rely on your living will for instructions as to certain aspects of your medical needs, like instructions as to whether or not you want to withhold any extraordinary life-sustaining treatment. For example, do you want a heart pump? Do you want a respirator? What are the events in which you wouldn't want those things? What, is there a specific time you wouldn't? Do you have specific beliefs, like religious beliefs or some kind of belief that says that you want certain things, but not necessarily everything? Maybe one of your beliefs is that you need to have the food and water, but that you don't want the extreme of everything else. we also need to know about pain relief and for medication. So a lot of times what we say is, in a circumstance where two doctors, we usually try and have it a consensus of two doctors telling your agent under your healthcare proxy that you're in a permanent vegetative state, you're terminally ill, you're not going to live a meaningful life. Those are the triggering events. Then you don't want any extreme measures. You just want pain management and comfort care. So it's basically like hospice kind of mentality where you're keeping you're comfortable, you're not in pain, and you're just going to live your life like that. And some people deviate from that. I do have a lot of clients who do reflect on their religious beliefs to deviate from that. And it's really a learning process. Like, and I tell people this story all the time. My mom, about 17 years ago, had elective surgery where she had the same surgery twice in a 36-hour period. And we almost lost her. And she had to go on life support, a respirator to keep herself going after the second surgery. But at no point were the doctors telling us that she wouldn't survive. They were just telling us that based on the trauma to her body from having those surgeries so close together, she needed time to heal and get her body to a point where she could breathe on her own and she can slowly start to come back to the person that she was. And she's actually in Florida right now, waiting for me to join her. So she's doing very well, and life-sustaining treatment was relevant in that case, and we weren't being told that she wouldn't have a meaningful life. So that was important in the conversation. And I have a question from Kathleen. How do you make a healthcare proxy official? So a healthcare proxy in New York is a document that is signed by the person who's designating the agent. So you would sign it with two witnesses, and those witnesses cannot be the parties that are named as agents, and they really shouldn't be related to those parties that are named as agents. Okay. So the question then becomes, when you hear that on the living will, you're being asked about life-sustaining treatments and those types of procedures, the question you really have to ask yourself and then express to your agent is, would you want extraordinary life support if you had no chance of recovery? And so in the living will, we often have this conversation and we talk about this because it's important, and that's really what you're giving your agents permission to discuss with the doctors. Because here in New York, we presume that you want life-sustaining treatment unless there is a clear and convincing evidence as to your desires. Clear and convincing would be that the living will meets that requirement and says, no, I don't want it. Yes, I want it only in this circumstance. I only want, if in a religious belief, I only want X and not everything. So a living will provides instructions to the agent of the healthcare proxy or the healthcare provider as to what you would or would not want regarding extraordinary life-sustaining treatment under certain conditions. That is so important because basically what it's doing is it's giving the agents that you're naming that guilt release. It's hard to make decisions to pull the plug, on someone's life support. But if you aren't the one that's making the decision, you're just following through with this decision that's already been made because it's been expressed in the living will. It helps the agent have a little bit more comfort in knowing that they're not really making the decision, they're just following through on your wishes. And that is, having had over my lifetime opportunities where I have been the person to make that decision, it helps to know that I'm really not making it, I'm just expressing your wishes. And that's huge. All right. So who makes this decision if no healthcare directives are in place? So we've explained to you what happens in a circumstance where you control everything that's going on because you have the ability to still make your own decisions, or you've done your advanced planning and you decided that you've named the people that you think are going to make the decisions the way that you want them. But what happens if you didn't do that planning and something tragic happens and you're faced with medical issues? So if you do not have advanced care directives in place, then healthcare decisions may be limited or compromised. You can also lose assets and personal dignity. So no one has the legal right to make decisions for you. The way that they get the legal right to make those decisions is a court proceeding, which would be a guardianship, and that is to appoint a legal guardian on your behalf. And it is a court proceeding, so it does take some time. It is a few months, if not, maybe 4 to 6 months, sometimes longer, if in situations, and I've seen this, in situations where maybe the kids don't agree on who's got your interest in heart, they are arguing over who should be the guardian. It gets ugly and it could take longer and it's more expensive because you're fighting in court. So that's something to definitely consider, and a reason why, if you're listening to this and don't have these documents in place, there's clearly a reason why you were interested in this topic, and you should just rip the Band-Aid off and jump right in and make sure that you have these documents. Okay. So when you're in a position where you're at the hospital and you have not yet done those advance directives, and there isn't a guardianship in place yet, but there's an emergency at hand, New York State does have the Family Health Care Decision Act. It was signed into law by Governor Patterson on March 16th, 2010. And this allows a healthcare surrogate to make healthcare decisions, including end-of-life decisions, if you lack the ability to make decisions for yourself, and there's no advance directives or hospital documents in place, and you're in a hospital or on hospice. All right, because sometimes if you're going in for a procedure, very often the hospital will ask you if you have a healthcare proxy, and if you don't show up with one or have one on record, they will have you sign one there if you're able to. So what does this law say? It gives a hierarchy of the healthcare surrogate and who can make the decision. So we start number one with the guardian. So if by chance there was a guardian appointed, then the guardian is going to be the person that makes the decision over everybody else. If there was no guardian appointed, then the next in line would be the spouse, if they're not legally separated, or a domestic partner. If we don't have that level in place, then we're talking to the children who are over 18. And it gets complicated when you start to get down to this level, because there could be multiple children. And as I alluded to before, multiple children may mean multiple opinions about what your decisions are. So that becomes complicated because there may not be a meeting of the minds there. And in that case, the doctors may just have to do everything to save you, because there's no meeting of the minds and they need court intervention. Following the children, it would be parents making the decision. If not parents, then it's your siblings. So, I hope you get along with your siblings and that you have good conversations with them, because it's very possible that those siblings are going to have to make those decisions if you haven't signed these documents. And lastly, they would resort to a close friend. So there is a hierarchy, but certainly not one that you would want to rely on, because that hierarchy doesn't necessarily assure you that the person that is going to be picked to make the decision is going to follow your wishes and make the decision that you would have made. Okay. If you don't have the documents in place, and we have a little bit of a pause where there's not an urgent medical need where we're in that surrogate hierarchy, we are looking at guardianship. So guardianship is a personal thing, and a guardian can also make important personal decisions for the incapacitated person regarding their routine, major medical and dental treatment, living arrangements, education and training opportunities, applications for government benefits like SSI and Medicaid. The court gets very involved, and the court oversees everything. So it's not just that someone gets appointed and then once they're appointed, they move on. They have to keep reporting back to the court at a minimum on a yearly basis to make sure the court is aware of what's going on with you and that everything's being managed the way the court feels it should be managed. So I often get this question when I'm doing seminars in person, but what about a DNR and a MULST? So a DNR is a do not resuscitate order. It's written by a doctor. Your healthcare agent can have permission to talk to the doctor about signing a DNR. It is an order specifically done by a doctor, and it's saying that in those extreme circumstances, you don't want to be resuscitated anymore. You just want to be left alone. The other question I get is about a MOLST, which is a medical order for life-sustaining treatment. And this comes up most often when we're talking in terms of like EMTs coming to the house, because sometimes EMTs will question whether or not they have the authority to rely on a healthcare proxy. And if the healthcare proxy isn't right up front and readily available, that becomes even more of an issue. The MOLST is also something done by your healthcare provider. It talks about CPR and other life-sustaining treatment. It is generally a neon pink 4-page document. If you have an opportunity, which I encourage everybody to supplement their healthcare proxy with the MOLST, because it is, it goes in detail over things like, do you want to be intubated? Do you, at what level do you want life-sustaining treatment? There are very specific questions that your doctor will sit with you and go through all those questions, and every couple of months, sometimes every 6 months, they will review it and make sure those are still your wishes. That is a form that you should put on your refrigerator if you have an opportunity, and I encourage you to, if you have an opportunity to do that form, because if an EMT comes to your house and they are handed that, they will follow those guidelines because that was done with a doctor and they are giving specific orders about what would happen. Okay. Otherwise, there's a gray area in there as far as what they're relying on, and some of them will look for a supervisor to get involved, which could cause delays in the treatment that you're in need of or don't want. Okay. So how do you protect yourself then, if all this is going on? Well, a plan protects you. You make sure you're accessing the care you need, control how healthcare decisions are made with healthcare directives, like a healthcare proxy, a living will. And these documents can be changed at any time. Nothing's carved in stone. If you sign the documents today and 3 months, 6 months from now, you get into a fight with the person that you've named, or not even that. What if the person that you've named either loses capacity on their own or they pass away? You want to make sure that your document reflects your most recent decisions and is constantly evolving to take those things into consideration, as long as you have the capacity to sign new documents. We are always available to assist with drafting and supervising the signing of those documents. And they are so very important that any questions that you have, we could certainly respond to. I know that there's 2 questions, and I just wanted to summarize, and then I will answer those 2 questions that came up. So we discussed your healthcare proxy and your living will. The healthcare proxy is the document in which you name the individuals, the agents that are going to make medical decisions for you. The living will is the document that lays out for those agents exactly what you want, whether you want life-sustaining treatment, do you want IV treatment, do you want food and water, at what level, what has to be triggered in order for you to not want that kind of care. All of that is laid out in a living will. We discussed that there is a pecking order and a hierarchy for who makes decisions if you don't have those documents in place. And if it's not an emergency, a guardianship is likely where it would go, because the judge has to appoint somebody to make that decision in a non-emergency. And you can protect yourself by taking the steps to get a plan in place. Because like I said, you've taken the steps to be part of this conversation today and hear why this is all important. And the next step for you is to find a way to get those documents done. Schedule an appointment, have a conversation, get those documents done. Okay, so we have 2 questions. In New York, are you allowed to have medication for death purposes if it is known you will die in constant pain? So I do not believe that New York allows for that kind of assisted, that's such a strong word, but assistance in dying. I don't believe that that's allowed in New York. Hospice does give you morphine to help with the pain, but if we're talking like a Dr. Kevorkian kind of experience, that is not something that New York is recognizing at this time. And then if you are a healthcare proxy and the proxy is changed by the person for whom you are the proxy, will you be notified? You should be notified of the change. It's not the same as on a power of attorney where there's a mandate that you have to be notified. You should be notified of the change, but I don't know that there's an absolute requirement for you to get notice, because those documents can be changed so often, and whatever forms go to the medical professionals are the forms the medical professionals are going to rely on. Okay, and somebody else was typing a question and then it disappeared. So I don't know if you changed your mind or if I answered it already. And if I answered it already, that's great.
I have an answer for this. It was Corinne. She was wanting to know how this is different from the one that she executed in 06.
The only difference, and I don't have any documents in front of me to see that, the only difference that you may have, and 06 was pretty late after the HIPAA laws were in place, but sometimes if you sign documents back in the early 2000s, the privacy laws, the HIPAA laws weren't in effect until like the early 2000s. So there's the possibility that you may just need to look to see if you have that language in your healthcare proxy, or at the very least, you're doing a HIPAA authorization to allow for your agent to get private medical information so that they can make those decisions. And that could be a document that is done to supplement what you have.
Bob Buchanan is living out of state in Ohio, and his question is, can I use you to develop a standard will and a living will and any other appropriate documents?
Okay, so the answer to that question is we are not licensed in Ohio, and every state is different with their documents and their requirements. There's little nuances that every state requires. And like terminology that they use with regard to how they reference the different individuals and their role is different state to state. So I would definitely suggest that you have the documents done in Ohio, but that doesn't mean we can't help you with a recommendation for an attorney that's near you. So you can certainly call in, and we have connections across the nation. You could certainly call in and get that information from us, and we could give you the name of somebody we would trust. But we can't actually do those documents if you're not a resident of one of the states that we're licensed in. Yet, is anyone at Russo Law licensed in Florida? Yes, we are licensed in Florida, and yes, we do Florida documents. Okay.
Mayor sent in a question, is there a difference between a health proxy for a hospital and one at EMS?
So the difference would be, I mean, a healthcare proxy for a hospital would be your standard healthcare proxy naming your agents. And like I said, with the EMS, they do look at the healthcare proxy, but don't always rely on just your conversation in a living will to not provide the treatment. But if the most is signed, they will rely on the most. So you have to, I would have all three of them done so that you don't have, there's no question with the EMT. And then I also see that in the chat, how is a HIPAA authorization related? So HIPAA authorization is just making sure that it's understood that the people you're naming to get your medical, to make your medical decisions have the authority to get medical information. So in an emergency, they'll get the medical information about the emergency, but that doesn't mean that there's not something else going on in your world that you haven't been telling people about. And I tell people all the time, you know, my mom is a nurse by trade. And so what she usually does to protect us, because my dad was always a very sick man. And, you know, we were always hearing about doctors and running to this appointment and that appointment. So in a way to protect us, she often will be dealing with something and go and get all the medical information first before she tells us what's going on. And in that circumstance, we may not know that something is going on, but she may have an issue, a medical issue that we have to step in and be the agent on. And it may have a bearing, what she's going through may have some kind of bearing on the decisions that we would be making for her. So it's helpful to have that added authorization under the HIPAA laws to get the medical information, so we know we're doing everything we can for her.
All right, I'll jump in here. What makes Russo Law Group different? It's our dedication to our clients, our scope of legal services, and the level of experience. Right? Short and simple. We will not learn at your expense. Here are the services that we provide and how we can help you and your family. I would urge anyone who has questions related to these directives, estate planning in general, or questions about our services, give us a call. We're happy to speak with you after this webinar. We, of course, appreciate all of you for joining us, taking time out of your day. Please leave us your feedback in the webinar survey. And I know Deanna and I look forward to reading your responses. The survey will appear on your screen momentarily. Deanna,
Yes. Thank
any
you so
parting
much.
words?
I just thank you so much, and I hope everybody has a nice day. I hear, it's getting a little muggy out there. Stay
Getting
cool.
close to getting in that summertime.
Yeah.
Deanna, thank you for your presentation, and until next time, everybody, please be well and stay safe.